Good morning. Thank you for joining us and welcome to our webinar on repurposing town centres. You will see that your cameras and microphones are switched off. That's due to the number of participants. But if you would like to raise a question, then please do so through the chat facility and we'll try and answer it at the end of the webinar. We hope everything runs smoothly. But if there are any technical difficulties, then please raise these again through the chat facility or email Julie Scheller and she will try and sort them out. Our speakers this morning are Nathan Holden and Mitchell Ball. Nathan heads our local government practice and specialises in local government law, particularly powers relating to land disposal, CPO, EU procurement and state aid. Mitchell Ball specialises in real estate and planning law and has a particular specialism in advising local authorities on their town centre schemes. We will be circulating an evaluation form at the end of the webinar, so please do give us your feedback. I'm now going to hand over to Mitchell to outline the purpose of the webinar.
Thank you, Fiona, and good morning. So the plan for this session is to start off by looking at the present position, the state of play of our town centres at the moment. And Nathan will take that section shortly. Once we've looked and reminded ourselves of the present position, we'll then look to the future. We'll crystal ball gaze and see what our town centres might morph into. I think if we all agree that a degree of transformation is needed, what does that transformation look like? So we'll look at the present, then we'll look to the future, and then thirdly, I guess the tricky bit, how do we get from the present to the future? What is the process of transformation? What are the obstacles in the way of that, and how might we overcome those? So that's the format. So as I say, first off, we'll look at the present position, and I'll hand over to Nathan Holden just to remind us of the scene at the moment on a typical town centre. Over to you, Nathan.
Yes, thank you, Mitchell. It feels a bit early to be talking about Christmas, but I feel as if I'm the ghost of Christmas past here, talking about where retail presently is at. As these slides illustrate, and the pictures illustrate, our town centres are in a bit of a sorry state. You don't need to be a retail planning consultant to tell you that not all is well in our towns and cities, as you can see with your own eyes looking around. And also, I suppose, sometimes it's easy to think that COVID-19 is the main contributor to this, given that that's when we've seen the largest decline. In reality, I think it's been recognised for some considerable time now that the process to get us to where we are today has been ongoing for some considerable time. And COVID-19 has, to a large extent, only accelerated that process, not precipitated it. And this decline, I think, has now been brought into sharp focus by the COVID-19 pandemic, and the need to really think about what we do with our town centres. Go to the next slide, please, Fiona. Looking at some of the difficulties, I don't want to dwell too long on this, because I think they're pretty well understood. But as the slide illustrates, the problems are many, along with long-standing issues around poor infrastructure and transport provision. The biggest problem, the one that retailers really face, is the excess of retail capacity. And this is in large part caused by the increase in online shopping. In some respects, the current position has a lot of echoes of the threat to the high street and town centres in the late 1980s and 1990s. This time around, instead of hypermarkets and shopping centres being located on out-of-town locations, what we have instead is warehousing and technology that's the culprit. This increased competition has a profound effect also on town centres and retailers' ability to compete generally. Obviously, of course, it gives rise to higher operating costs and higher business rates in comparison to those internet operators. And also, of course, the knock-on effect for local authorities is that the fewer shops and businesses that are located in their towns and cities diminishes their rate income, their business rate income. And of course, that for a lot of authorities these days, given that of course there's a shift away from central collection of business rates to local authorities, has a major impact on local authorities' ability to raise income and use that income to help promote and generate their towns and cities. So what, if any, future is there for our town centres? I shall now pass you over to Mitchell to take you through the next slide.
Thanks, Nathan. So I guess crystal ball gazing then as to what the future landscape might look like, and I think it's fair to say it needs somebody with greater imagination and artistry than a lawyer to answer this. But there are some very much recurring themes, and I've set those out on this slide. A lot of local authorities at the moment are producing town centre master plans, and when you look at those, you see very much recurring themes, and these are the ones. So I'll run through these now. If top of the list, retail. It's possibly a bit bold of me to be saying retail, given Nathan's comments and the boarded up shops that we see on the high street. But I think what we have to remember is that retail in itself isn't the problem. As Nathan said, it's an excess of retail capacity that we have, and we need to move away to a less dense sort of retail offering. So I think the truth is, as a nation, we enjoy the recreation of going to shops, and so I think, as I say, retail will continue to feature significantly. I think one only has to remember a few weeks back when Mr. Johnson announced lockdown 2 to come into effect on the Thursday. What you saw on Monday, Tuesday, and Wednesday was everyone flocking to the high street, to the town centres. Shops having to extend their opening hours, shopping centres having to extend their opening hours to accommodate that, because we wanted to get the shopping fix. So I think a good number of shops still on the high street and in the town centre. I think secondly, food and drink provision. So coffee shops, cafes, restaurants and bars. We're still an affluent country. We like the recreation of going out to meet people in cafes and in bars. The fact that you can go to Tesco's and buy Pizza Express pizza to cook at home is by the by. That you can get Starbucks coffee to brew at home, or you can go to Nando's and get a click and collect. It doesn't alter the fact that we like the recreation of going out to those cafes, bars and restaurants. So I think a strong continued presence of retail and food and drink offerings. One change I do see is a shift towards away from the national chains towards more independent operators. So smaller retailers, local operators, cafes and that type of thing. In November, just a week or so back, LDC and PwC issued the findings of one of their reports on how town centre retailers and cafes and what have you had fared during the COVID period. And they found very distinctly that local operators had fared a great deal better than the nationals. And they put that down to numerous factors: lower cost base, greater agility, able to move in and out of different product lines. But I think there's another factor at play here. I think if there's a good local operator, I think we all have a sort of sense of loyalty and a wish to support them. Now, certainly during the first lockdown, the Ball family, we live in Sutton Coldfield in the West Midlands, and every Saturday night we were going to a different takeaway, and the children chose a different sort of outlet each Saturday. And part of that was because there wasn't a great deal else to do sort of recreation wise during that period on a Saturday evening, but also there was a strong sense in which we were trying to support local businesses to help them keep going. So as I say, I think a continued significant retail presence, continued continued significant food and drink offering, but perhaps a shift towards more local operators. And there's a viability issue linked to that I'll come on to later in the seminar. I think other leisure uses will continue to focus significantly, things such as hotels, cinemas, bowling alleys. Cinemas seem to have a continued appeal, despite the fact that, you know, we can stream films and we have Netflix. People like the big screen experience, they like going out, they like the recreation of that. And cinemas and facilities such as cinemas can draw people into the town. They can create footfall throughout the day, and they draw other businesses in, other restaurants and cafes. These type of developments are not easy to deliver. Clearly a cinema takes a lot of space, they're expensive. The landlord or the developer is normally having to give a significant capital contribution to the tenant towards the expensive fit out, the screens and projection equipment, but those facilities can add a vibrancy and a footfall to the high street. I then think educational uses and health uses will form a significant part. The need for education, the need for health are enduring requirements. They're clearly going to continue. And whilst we've sort of dabbled with online learning and with Zoom meetings with GPs in the health sector, I'm not convinced there's going to be huge transformation. I think students, whilst they can receive a lecture online, I think they like the process of going into college to meet people, and that's all part of the experience. I think people like sitting down in front of their GP, rolling up their sleeve, explaining their concerns and their worries. So I think health and education will be an increasing part of the town centre landscape. Offices, again, slightly bold to say, but I think offices will continue to feature heavily, despite the fact that lots of us have been working from home. I think rumours of the demise of offices are very much premature. I think you know, we like still to go into the office. We like the routine of that. We like you know, the social aspect of meeting colleagues, and I think a lot of things are more effectively and efficiently done face to face rather than endless emails and sort of Zoom calls and telephone calls. I think that office space will be more flexible. And more informal, so maybe with a coffee shop within a coffee bar within the offices, and a number of the meetings taking place in the informal surrounds of that coffee shop, rather than the sort of more formal office structure where you've got meeting rooms that are sort of sat empty for much of the day in the week. But I think office is still featuring. Then residential, which I think, if anything, is probably the game changer here. We have a national published target housing need of 300,000 new units a year. It's been that for some time, and we've consistently failed to hit that target. At the same time, we're building over the greenbelt to the alarm of a number of people. Yet we've got vacant space in our town centres that sat there boarded up. So I think it's only a matter of time until we see significant transformation of retail space, redundant retail space, into residential. That's clearly going to be selective residential. It's not going to be big family homes with big gardens, because you won't get the density that you need in that respect. So maybe PRS, build to rent, social housing. And we've seen, for example, the John Lewis Partnership issuing plans in the coming years to transform retail space at 20 of its sites into social housing or build to rent, and intends to make 2 planning applications in that respect in 2021, and is actively working with landlords to facilitate that. So certainly a move towards more residential. I think linked to that is creation of more public realm, so more green space, more space for us to just go and sit and be outside and to dwell. I think throughout the COVID period, we've remembered the importance of spending out time outside and the pleasure that that can bring, the health benefits that that can bring, but you need the decent spaces created within our town centres, breaking away from the sort of concrete mass of created for retail density, so that we can just sit and spend time outside, public exhibitions, outdoor performances. So I think public realm very much featuring. I think that supports the residential progression, because people will want that outdoor space. And then finally, I think we're going to become less car focused. So some movements around transport, pushing the cars away from our town centres, partly because of air quality concerns, but also to stop pedestrians and cyclists having to vie with cars just for space. And so you've seen the likes of Birmingham City Council trialling approaches over recent months to stop cars coming into the central core, introducing bus gates to limit the car access. Now that has created some difficulties, excuse me, with traffic difficulties outside of that central core, whether because of the cars can't get into it, so that's had to be suspended. But the general trend of pushing the cars away, opening up more green travel ways for cyclists and for pedestrians, I think is a trend very much there to stay. So I think that's the sort of overview, recurring themes of what the town centres of tomorrow might look like. Back to you, Fiona.
Thanks, Mitchell. That's really interesting. As with any change, it's never straightforward. What do you see as the main obstacles to achieving those transformations that you've talked about?
Thanks, Fiona. I've put so up on the slide there is 4 obstacles which I see, and I'll give you these 4 thoughts, and then there's a couple of slides to demonstrate this. So town planning is one obstacle. We're not going to achieve holistic, whole-scale transformation if the town and country planning sort of landscape is based on ad hoc development, ad hoc planning applications for individual buildings. I think we need more town centre master planning, and we're seeing local authorities coming forward now in significant numbers with town centre master plans showing a vision for the whole town centre. So only a couple of weeks back, Solihull Council issued its town centre master plan for the centre, and that's the final draft plan. Hopefully that'll be accepted and adopted as part of a local plan, and that shows, for example, over 1,100 residential units, significant open areas of public open space, and redevelopment of the local authorities, the council's own offices, stepping forward and filling part of that space and becoming part of that built environment. So as I say, so firstly, a need for more master planning forming part of the local plans. I think also we've got a problem of fragmented ownership within a typical town centre. The land holding is very excuse me, very diverse. Lots of different land holdings, some of it owned by the private sector, some of it owned by the public sector. People with different motivations. There's some investors are holding property where they've got a tenant in situ. Tenant doesn't want to go, very happy to stay. Other landlords have got empty units. Some units held by developers who really want to develop. Some units held by developers who've got no experience or no inclination or no funds to redevelop. So a really mixed sort of bag in terms of land holding. And that can, again, present a challenge to holistic redevelopment. I think then just core viability. Certainly in the private sector, you're only going to get a development take place if it's viable. So if the end value of that development is sufficiently high that it can meet all of the costs, the land costs, the build costs associated with that redevelopment, and still provide a development profit for the developer. And then just finally, what I would refer to as loss of immediate income. You might have a developer either a private developer or a local authority for that matter, who's got a property, has a vision for that, can see how it might be transformed into what could be a viable development in years to come. But if there's if there's an occupier there paying immediate income, paying rent, it's quite difficult to push that immediate rent away to get vacant possession, to chase some sort of vision as to the future image of what that might become. Whether that's a commercial developer or a commercial investor or a local authority, there's probably interest to be paid either on a commercial mortgage or to a public works loan board. And as I say, the prospect of losing that immediate income can be a drag on the move to develop. So we've got a couple of slides. If you could bring up the next one, please, Fiona. Yeah, so I mentioned the need for town centre master planning. This is Walsall. This is part of the master plan for Walsall town centre. It's probably a little bit difficult to see, but you have core areas. So there's a retail core, there's a leisure core, there's a residential core. You've got areas for public open space, for green areas, and then you've got transport improvements, green infrastructure, cycle lanes, pedestrian areas. So all of those elements I touched on earlier: retail and food and drink and leisure and open space, green areas and transport improvements, forming part of that master plan for the town centre. And that's very typical of the master planning that we're seeing emerge. If you could go on to the next slide, please, Fiona. So I mentioned the problem of fragmented ownership. That's a land registry overview plan for the centre of Sutton Coldfield. And the land ownership position in the centre of Sutton Coldfield is relatively focused, yet still you can say, I haven't counted them, but there's lots and lots of different land interests there. And as I say, that can be an impediment to sort of holistic movement forward if you're trying to get everybody to work together to bring about a transformation. So those are what I see as some of the obstacles. What we'll do now, I'll hand back to Fiona, but the plan then, I think, Fiona, is to move on to look at how we can overcome those obstacles.
Yes, and particularly the approaches that are available to local authorities to take the lead in these developments.
Yes, thank you. I'm just going to talk a little bit now about some of the legal tools that local authorities have at their disposal to hopefully arrest the decline in their town centres, or ideally, even better still, deliver some kind of economically sustainable future. I'm going to run through those topics in the next few slides. So Fiona, if you could pass the next slide, please. As the slide says, local authorities have broad powers of land acquisition. The most obvious of these, of course, is Section 120 of the Local Government Act 1972, the general power to acquire land for either to support a local authority's functions or for the benefit, improvement or development of their area. This could, of course, also be used in support of the exercise of a local authority's general power of competence under Section 1 of the Local Government Act 2011, the power to do anything that any individual may do. There are, of course, more specific powers to consider. For example, you might think of using Section 227 of the Town and Country Planning Act 1990, the power to acquire land for planning purposes. And there are, of course, other powers, many of them. For example, Section 17 of the Housing Act 1985, the power to acquire land for housing purposes. And as I say, there are other powers. These are just some examples of what's available. And finally, on this point, it should also be remembered that local authorities also have a specific power of investment. Section 12 of the Local Government Act 2003 provides that a local authority may invest for any purpose relevant to its functions in land or for any other purpose under any enactment. Now, of course, that sounds incredibly flexible and very comprehensive. However, of course, the exercise of the power has to be read through the lens of guidance issued by the Secretary of State, which of course over the last few years has been increasingly tightened in response to some of the activities of authorities looking to invest in commercial property. And you don't have to look very far. For example, you don't have to look at, say, Croydon Council, where sometimes that kind of strategy can go somewhat awry. Clearly, they are in some financial difficulty now as a consequence of some of those investment decisions. But as I say, in summary on this one slide, there is plenty of powers available to acquire by agreement, and there's lots of flexibility there. So can I have the next slide, please, Fiona? It's not always, oh, sorry, that slide's in the wrong order, actually. Can we go to the next slide? Yes. It's not always possible to negotiate the acquisition of land, and so alongside the power to acquire by agreement, you'll often find a power of compulsory acquisition. If you do any sort of research on the use of compulsory purchase powers, the most popular of the powers available is the planning power, of course, section 226 of the Town and Country Planning Act 1990. This is the power to acquire land compulsorily because a local authority thinks that the acquisition of the land for the purposes of its development, redevelopment, improvement will promote the economic, social, environmental well-being of the local authority's area. Roughly 75% of all compulsory purchase orders, and when I say that, I'm excluding highway CPOs because they're actually dealt with by the Department of Transport, not by the Ministry of Housing, Community and Local Government, are promoted on this basis. The remaining 25% are largely made up of housing CPOs in reliance on the part of Section 17, which deals with the power to acquire compulsorily. This would be a power to acquire land for housing purposes with the intent of delivering a qualitative or quantitative housing gain. Sometimes the planning power is used instead of the housing power. Sometimes the housing power is used instead of the Town and Country Planning Act power. So of course there is a bit of an overlap between both of those. But they are both incredibly important tools for delivering new development. In fact, housing, I think, is having a bit of a comeback in terms of the use of that particular power. I'm working on a scheme at the moment that's using the housing CPO powers rather than the Town and Country Planning Act powers. So Fiona, could you go back a slide, please? One thing I think is sometimes forgotten is that councils, although they don't own as much land in their towns and cities as they once did, are still significant landowners. They still have a huge stake in the towns and cities that they're responsible for. And of course, with ownership often comes constraints on the use of that land. For example, it could be that the development you're proposing to carry out may interfere with local residents' rights to light, for example, and any development could give rise to a claim or an injunction, in fact, to stop the development taking place. Or that it could be that its use is constrained by a restrictive covenant as to use. So it might be the land had been acquired and a restrictive covenant imposed as to how that land could be used so many years ago. There is, however, quite a neat way of partially dealing with this problem. Appropriation is the process by which a local authority formally transfers the basis upon which it holds land. It changes its statutory function from one function to another. The council can appropriate land as long as it's no longer required to be held for the purpose that it's presently held, and the new purpose to which it will be held is one that it could have lawfully purchased the land. Now, if you appropriate land, transfer its function from another function, and you happen to appropriate it to a planning purpose, then of course you can take advantage of sections 203 to 205 of the Housing and Planning Act 2016. This allows for the restrictions on the use of land to be overridden for the planning purposes for which the land has been appropriated. In return, the person who has the benefit of the right is entitled to compensation on a compulsory purchase basis. Now, I think what's often forgotten is that this same power is also available for overriding restrictions affecting land, where a local authority acquires land either by agreement or compulsory. So it isn't just confined to appropriation, although appropriation is one of the areas where it's used most. The other point to mention about the appropriation power and the engagement of Section 203 to Section 205 of the Housing and Planning Act 2016 is that, of course, as I've mentioned, compensations payable, but of course, you always have to remember that it also applies to appropriations that have been made in the past, prior to the introduction of the Act. There are some saving provisions to ensure that where you've appropriated land previously and relied not on sections 203 to 205 of the Housing and Planning Act, but rather the old section 237 of the Town and Country Planning Act, that appropriation and the effect of it will still apply. Could I move on to the next slide, please, Fiona? Moving on to a slightly different topic, not only can local authorities acquire land, but they could also, for example, develop land for themselves. So next slide, please, Fiona. For example, a popular approach for local authorities is to relocate council facilities to help kickstart development. Not dissimilar to the example that Mitchell gave of changes afoot of relocating of central government departments, for example, into regional areas, into other local authority areas. However, from an EU procurement perspective, this is far from straightforward. The acquisition of a built development or land is exempt from the scope of the public contract regulations. However, if the contract makes provision for the carrying out of works, then the contract may fall into the category of works contracts that are subject to the procurement regulations. The difficulty is that local authority development for its own purposes, or from which it derives a benefit for itself or for its residents, is likely to involve entering into a works contract. The key determining factor is whether, at the point the contract, the development agreement is entered into, the contract imposes immediately binding development obligations. Now, up until November 2018, the courts have accepted that an agreement that did not impose immediately binding development obligations would not be caught by the public contract regulations. And the logic, of course, was that without development obligations, i.e. the obligations to carry out some works, then the agreement could not at that moment in time be described as a works contract. However, this position changed radically with the Court of Appeal's decision in West Berkshire Council and Faraday, where the Court of Appeal held that a postponed development obligation was the same as an immediately binding one, and therefore this approach would no longer work. So what this has meant in practice is that what had been a very useful tool in the armoury of local authority development, this idea that you could postpone development obligations, not have them triggered at the point at which you enter into the contract, would mean that you could effectively classify a contract as a land transaction, and land transactions, of course, are exempt from the public contract regulations. The Faraday case, of course, has changed that now, and what it means in effect is that any type or any attempt to postpone development obligations in that way will not simply be valid. So the position as it stands at present is quite difficult to interpret, and largely it relies on attempting to limit the control councils have or given over the development that's delivered. Or alternatively, they seek to somehow fall back on some of the statutory controls that won't give rise to a works contract. For example, simply relying on planning obligations, which are not development obligations for these purposes. Now, this leaves councils in a very unsatisfactory position, in my view, in the sense that what it does mean is that they leave them in the position of balancing the risk of challenge by imposing controls. So if they want to impose controls to deliver something that is for the benefit of their area, of which they derive some benefit, they run the risk of some kind of challenge potentially by doing so if they choose not to go through a public contract route, against having no proper control but being compliant with the public contract regulations. So if you want to take that route of not wanting to follow some form of OG process, then of course you're left with potentially having very limited control over the outcome of the development. Now, will the procurement position change as a result of Brexit? I mentioned OJEU just a few seconds ago. Of course, the whole OJEU system, the Office of the Official Journal of the European Union, and the UK's access to it will end on the 31st of December. It's going to be replaced by a new system called Find a Tender is the process that will replace it. But it has to be remembered, of course, that even with the end of the transition period, that doesn't mean the end of the regulations. The regulations will remain in force until such time as they are altered by Parliament. They will continue because they are UK regulations. Public contract regulations 2015 are UK regulations. So anyway, I'm now going to pass back to Fiona, who's going to introduce the next slide.
Thank you. Now Nathan and Mitchell are going to look at some of the ways that local authorities can work with private developers.
Thank you, Fiona. We're now going to talk a little bit about some of the structures that are available for bringing forward local authority developments, notwithstanding some of the constraints that I mentioned a few moments ago. Typically and historically, the most attractive model has been the contractual joint venture. And to put it simply, a council puts land in, because it tends to be land rich and cash poor, and the developer, the development expertise and funding. Although, of course, increasingly, the latter is also provided by councils, often through its ability to borrow at highly competitive rates or through the Public Works Loans Board or other sources, or in effect using its good covenant. And that's something that Mitchell will be picking up later on. And the advantages of these arrangements are that they're very simple to set up, and they have a sort of tried and tested seal of approval. This idea of a simple contract, as it were, that dictates the relationship between council and developer is very attractive because of that simplicity. One of the key disadvantages, however, is that it's difficult to build in flexibility to allow for changes in circumstances. The contract would have to be varied if you wanted to amend what was to be delivered potentially. And of course, in itself, if you've gone through an EU procurement route, has its own issues. A different approach is, of course, to participate or set up some kind of joint venture vehicle, some separate entity. And these, of course, come in lots of different varieties. You've got limited companies by shares, limited liability partnerships, community interest companies, companies limited by guarantee. There are lots of different models out there. Even limited partnerships themselves, that's another model altogether. Now, from a powers perspective for local authorities, the limited company presents probably the easiest and simplest approach, because it's the model that's referenced in the Localism Act 2011 and, of course, the Local Government Act 2003 as the correct model for local authorities participating in a venture where they're acting commercially, acting for purposes of generating a profit, acting for the purposes as a commercial investor would act in practice. The limited liability partnership route, and one that's quite attractive for reasons I'll mention in a minute, is somewhat more problematic. A key advantage of the limited liability partnership model is that it's tax transparent, which by that I mean that the participants in the joint venture pay tax on their share of their profits individually. Normally a company would pay share its profits on its overall profits, irrespective of the underlying ownership. Limited liability partnership, very different. Each partner, in effect, pays tax on their share. Now, of course, councils don't pay corporation tax. So limited liability partnerships are attractive in the sense that the council, in theory, is able to extract from the entity its share of the profits without having to have deducted any kind of tax. And for similar reasons, these sorts of models are also popular in the private sector as well. However, unfortunately, limited liability partnerships are not a model that is permitted by the Localism Act 2011 or the Local Government Act 2003. Therefore, to participate in an LLP, it's necessary to demonstrate that the main or dominant purpose of the participation in the entity is not commercial, but rather in order to perform some sort of function. Now, typically a local authority will identify economic development as a function. And this was the finding in the Peters and Haringey case from September of 2017. And what the court determined in that case was that so long as the main or dominant purpose that for the local authority's participation was in the performance of a function and not primarily for the generation of profit or to trade, then of course, then it was be permissible for it to participate in an LLP. Now, I have to hasten to ask, it is still possible to make a profit from such arrangements. It just has to be that any such profit is an incidental outcome rather than a main object of the arrangement. Another advantage of LLPs is that their establishment, and it's also true, of course, for companies as well, is that arguably there is no potential public contract regulation in participating or setting them up. Because, of course, simply setting up an LLP doesn't involve any form of commitment to procure works. The difficulty, however, with this approach is that when assessing whether an arrangement is caught by the public contract regulations, you're required to assess all of the contracts that will be entered into. You're required to consider the whole package, as it were. And it seems to me that in light of the Faraday case, which of course, as I mentioned, was all about trying to deal with what was perceived to be an attempt to circumvent the regulations, i.e. this idea that you can enter into contingent development obligations, as it were. My view is that the courts would look dimly on arrangements which appear to look as if they were attempting to circumvent the regulations. But of course, it's still a moot point. And I suppose the issue that we really don't know about, the elephant in the room, is to what extent the future changes to the public contract regulations might actually free up or make it easier to participate in such arrangements, depending on what view the UK government takes of the current regulations and how perhaps they should change in the future following our ending of the transition period and fully leaving the European Union. Now, in terms of the entity itself, i.e. the company you establish or the limited liability partnership that you participate in, as long as the entity is created or established for a commercial or industrial purpose, rather than in the general interest, and that's the wording contained within the public contract regulations, then it will not be caught by the public contract regulations. So in theory, the entity would be entitled to participate in procuring works without having to comply with the public contract regulations, because it wouldn't be a body governed by public law. So of course that would give some flexibility around the nature of that entity. However, of course, that has to be balanced against the participation in the first place by the local authority, which may itself be caught by the public contract regulations, because of course there would always be an expectation that the participation would lead potentially to some form of works contract. So anyway, on that note, I will now pass you back to Mitchell, who's going to take you through some of the other structures that are available. Mitchell.
Thanks, Nathan. So I'm going to briefly look at grant funding, forward funding, and income strip leasing. So we'll go through those and then hopefully have a few minutes at the end for any questions. If you go forward, please, a slide, Fiona. So grant funding, I think we all pretty much know what this is. It's where public money is invested in a project, not normally not with an expectation that it will be repaid, but to fill a viability gap, either to fill a viability gap or to sort of kickstart proceedings, to pump prime it, to get it underway when there's otherwise some traction to that development going ahead. So essentially, a viability gap is where, if you look at the end value of a development, it's not high enough to justify all of the costs, the land costs, the build costs, all the professional fees and what have you, and still give a profit. So the grant funding fills that gap. as a firm, we're directly involved in quite a lot of grant funding work, and I have to say that even somebody who's involved in this day in, day out, I find it quite a difficult landscape in this country. There's lots of different grant pots available, lots of different bodies administering them. Some of that grant funding is issued by local authorities, some by central government, some by combined authorities, some by the LEPs, some by Homes England. And I think from a developer's perspective, knowing what grant funds, what pots are available and what purpose they each serve and who to speak to about those is difficult. But if one can get beyond that sort of confusion, and I think there is some confusion, there is certainly grant funding available. There has been and is going to continue to be to help transform our town centres. So in the past, we've had generic funds such as the LGF, Local Growth Fund, that's been used towards a number of projects, but including town centres. So things such as the Civic Hall refurbishment in the centre of Wolverhampton, some works in the centre of Dudley have made use of LGF funding. I say that as a funding pot is nearing the end of its life, and is quite a generic fund. But we've got bespoke grant schemes coming forward, really focused on the town centre. So there's the Towns Fund, there's the Future High Streets Fund. And the Towns Fund in particular, this is a £3.6 billion grant scheme. So far 101 local authorities have made applications, and they're at different stages of the process. And that is, I had to ask my 10-year-old son over the weekend how many noughts are on the end of 3.6 billion, and there's a lot, and even when you divide it across 101 local authorities, it's still quite a lot of money to go towards bringing about this transformation. And as a firm, we're hoping to run a future seminar on the Towns Fund, because I think that'd be really relevant. So that's grant funding. Fiona, if you could move on a slide, please. So the next one is forward sale and forward funding. Now this has been used as a device to assist developers bringing forward developments in the private sector for many years. So if and what we're beginning to see is local authorities step into the shoes of the investor. So broadly, a developer may have a scheme in mind, say a town centre scheme, some retail units, coffee shops, cafes, bars, possibly hotel, and it would give the developer quite a lot of confidence to launch into that if he could forward sell that scheme, if he could sell it off plan effectively and know that he's not working speculatively, if he knows that as long as he delivers that and gets to the end and puts the leases in place, that somebody's pre-agreed a purchase of that at the end, so he knows there's a pot at the end of the process to give him confidence to proceed. And as I say, that local authorities are increasingly getting involved in this as the investor, the end purchaser, and that can help, as I say, developers have the confidence to crack on with schemes. So that's forward sale. Forward funding is one step further on from that, where the investor, whether that's a private investor or, as I say, increasingly a local authority, is not only agreeing to buy the scheme when it's finished and let, but is going one step further and is agreeing to sort of drip feed the purchase price through to the developer during the build period. So that gives the developer a flow of funds and obviates the need for him to go and get bank finance, for example, in order to meet build costs as the development progresses. And having the confidence of having a means of funding and a sale secured can certainly give a developer the confidence to proceed with something where he might otherwise be hesitant. So that's forward sale and forward funding. Fiona, if you could move on to the next slide. So income strip leasing. This is Another mechanism that where local authorities are getting directly involved in working with developers to make developments proceed when they wouldn't otherwise. I mentioned earlier that for any development really to succeed and to proceed in the hands of a private developer, it's got to be viable. So the end value is got to be sufficiently high to meet all of the build costs, the land costs, and provide the developer with a profit. Otherwise, it's unlikely to go ahead. And in terms of viability, if something isn't viable, there's not a lot of things you can do. You can either subsidize the costs, which is what grant funding does, or you can try to increase the end value of a development. And that's what income strip leasing manages to do. It increases the end value so that the value covers all of the costs and provides a development profit to a developer so that something goes ahead. So how do you magically increase value? Well, in a traditional model, if you had, say, a town centre development proposal, you might have a number of shops in that, offices, food and beverage, coffee shops, hotel, and the developer would let individual units to individual operators, so would have a number of leases. And I mentioned earlier, I think the trend, certainly with retail and food and beverage, is probably going to be towards an increased number of local operators. So we have that trend. So more local operators rather than nationals. So smaller tenants, smaller companies. And there's certainly been a trend over recent years to shorter lease lengths. So whilst in the past they might have been sort of 20+ year leases, going forward the developer's more likely to be granting a number of leases to local operators for, say, 5 years, leases with break clauses. And the difficulty is, from a viability perspective, is an investor wanting to buy that investment hasn't got the surety of income, of long-term income, and it hasn't got big companies with big, strong covenant strengths buying into leases. So that's impacting investment value. The value is lower because you've got shorter leases, you've got local operators rather than big nationals. So you're going to struggle to get the end values that you want from that development, and without those end values you are likely to be facing a viability issue. One way of hiking that end value back up is income strip leases, where simply the local authority steps in and takes a head lease of the whole development. A local authority, despite financial pressures, is still considered to be a blue chip covenant, and is normally happy to sign up for the long term. Takes a long time view because wants to invest for the long term in the town centre. So you get a local authority taking, say, a 35-year lease, and the combination of that blue chip covenant on a long lease pushes the investment value up again in the hands of the developer and an investor. So you regain viability by hiking that investment value. So it's a win for the developer. All being well, it's a win for the local authority as well, because something proceeds and you get the transformation. And all being well, the sum total of income received by the local authority, which lets out the individual components, the shops, the offices, the coffee shops, the sum total of that income coming in to the local authority is hopefully higher than the rent that the local authority itself pays up the chain to its landlord under the head lease. So the local authority can make a profit each year. So as I say, a win-win, but not without risk. There is significant risk with this mechanism, and it's not for the faint-hearted. Whilst all may be well in early years when you've got a sort of shiny new investment with lots of tenants and lots of interest, when you get to the back end of in 20 years time, when it's slightly faded, some tenants have gone away, some empty units, there's a real risk that the local authority is going to get is going to suffer voids. It's got units that it can't let, so it's not getting enough income in itself to meet its obligations under its head lease, and it will have to continue to meet those rent payments under the head lease. And if it's not got the income coming in from the development to meet those, it needs to find that income from other sources. So not without risk, but certainly is used as a method of making something viable within town centres, which wouldn't otherwise proceed. So I say some more mechanisms there that we're seeing increasingly used by local authorities to make things happen. Fiona.
Thank you very much. Right, so we're going to have a look at the questions now from the audience. The first is, what do you think is a realistic timescale to achieve a town centre redevelopment? I don't know who wants to start with that.
I think on time scale, sadly these things do take time. We've got the planning reform with the planning white paper, of course, and that's prompting local authorities to have sort of revised local plans in place by the end of the current Parliament. So that's what, 2024. So I would have thought, you know, over the next 3 or so years, we'll see more town centre master plans being firmed up. But then, you know, just the process of the legal process of signing things up, and then the build process means that you've got, I would have thought, you know, the next maybe 3 to 5 years, plans firming up, taking shape, deals being done, and then the sort of 5 to 10 year mark, things really, you know, being seen to be transforming on the ground. I don't know what you think, Nathan.
Yeah, I mean, the only thing I'd add to that is that if there's any kind of compulsory acquisition, that's obviously going to take anywhere between, I don't know, at least 12 to 18 months as a minimum. So of course that's always going to put a bit of a spanner in the works in terms of timing.
Sure.
Thank you. I think you talked a bit during your section, Mitchell, on funding. Are there any other central initiatives that could help fund the redevelopment of town centres?
Yeah. Oh well. Rumour has it that Rishi Sunak's found a money tree, hasn't he? if you listen to some people. So, I mean, hopefully, I think the transformation will be a combination of private development, because ultimately things to have longevity have got to be viable to bring developers to the table to carry out these developments. So a combination of hopefully finding viable development coupled with public funds to, as I say, fill viability gaps, or, you know, provide some impetus. And there'll be things such as the Towns Fund, I would say 3.6 billion, which is really a big chunk of cash. And then also initiatives such as I saw only on the business news today. Apparently, the housing ministry potentially relocating to Wolverhampton. I'm sure it's not, you know, there's plenty distance to go for that to happen. But initiatives such as that, where big central government functions could move into the regional areas, transplant a whole number of workers with bringing footfall and spending power, I think will make significant change to our town centres.
Thank you. I think we're just about on time, so thank you very much, Mitchell and Nathan. I hope everyone's found that really informative. Please do give us your feedback, and hopefully we'll see you again soon. Thank you.
Thank you.
Bye.
Bye.
Bye-bye.